Yes. Let me also state it here and now that I'm not a lawyer. I've never attended any law school or any class, but we do reading and apply common sense with the help of an appreciation of the Queen's language, that's English, which we all learned in school. So, with your kind permission, I beg to read Article 146, clause 1, 2, 3, and possibly end at, I think, 7. So, I will start with this. Removal of justices of superior courts and chairman of regional tribunals. 146.1. A justice of the superior court or a chairman of the regional tribunal shall not be removed from office except for stated misbehavior or incompetence or on grounds of inability to perform functions of his office arising from infirmity of body or mind. 2. A justice of the Superior Court of Judicature or chairman of the regional tribunal may only be removed in accordance with procedures specified in this article. 3. If the president receives a petition for removal of a justice of a superior court other than the chief justice, or for the removal of the chairman of a regional tribunal, he shall refer the petition to the chief justice, who shall determine whether there is a prima facie case. Now, this is any other justice aside the chief justice. So cleared. Let's move to clause 4. Where the chief justice decides that there is a prima facie case, he shall set up a committee consisting of 3 justices of the superior court or chairman of the regional tribunal or both, appointed by the judicial council, and 2 other persons who shall not be members of the council of state, nor members of parliament, nor lawyers, and who shall be appointed by the chief justice on the advice of the council of state. So note here, there is room for those who are justices and also ordinary members of the country like myself. I'm not a lawyer, I'm not a member of parliament and all that. Now, that will be under the chief justice. That is for justices either than the chief justice himself or herself. Point 5. The committee, okay, let me do 6, which Mr. Appiaje did. Where the petition is for the removal of the chief justice. Now, when it comes to the chief justice himself or herself, in this case, herself, the president shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices of the Supreme Court, one of whom shall be appointed chairman by the president, and 3 other persons who are not members of the Council of State, nor members of parliament, nor lawyers. 7. The committee appointed under clause 6 of this article shall inquire into the petition and recommend to the president whether the chief justice ought to be removed from the office. You can read the whole and understand. Now, we have seen that there's been 3 petitions against our current Chief Justice. What is the duty of the president? When it happened in the past with regards to the electoral commissioner, there were this argument. Our brothers who know too much, they know too much to a point that when we were supposed to have a National Consultative Assembly in drafting this constitution, some of them said they know too much. They won't sit with our mothers and our fathers who didn't attend any law school. For them, drafting of the constitution is their bona fide, as the lawyers will say, bona fide property. They are blessed with all the knowledge, so they not go. Today, it's on record that the former president of the GJA, Ghana,
Alfred Mahama.
No. How do they, the Association of the Lawyers,
GB.
Ghana Bar Association. I had forgotten the bar. Today, Mr. Samuel, I don't know, but he is also Okujeto, that lawyer. He has been a member of the Council of State. He says his regret is not allowing his people to take part in the drafting of the Constitution. You can Google about it. He was the president then and said no, they know too much. They won't sit down with farmers. They won't sit down with market women to draft a constitution. So they didn't go. So with this constitution, their knowledge, their wisdom is not part of this. Today, they are running over. This morning, I listened to him on Joy. He disagrees with that and he has issues with the president not serving the Chief Justice with the petition before passing it on to the Council of State. But when it happened under Nana Addo Dankwa Akufo-Addo, they told us that he is only a conveyor belt. When it gets to him, his duty is to just pass it on. He's only a conveyor belt. Today, His Excellency John Dramani Mahama is not only the conveyor belt. And that when he received the petition, he should have copied the Chief Justice. That is, they say, natural, how do they say?
Natural justice.
Law of natural justice. That the accused must be given the right to also. But the question we ask ourselves is, have we gotten there yet? What law has President Mahama breached? We are in this country. When Nanado received the petition to remove Charlotte Osei, the EC den, Eugene Ahin came publicly, it's also on record, that when they received the petition, there were mistakes in it. At the presidency, they found mistakes, and for that matter, they had to call the petitioners and give it to them to go and make the correction and bring it. A conveyor belt, that's his mistakes. We have heard all this. Today, we do not know the people behind that petition against the removal of Charlotte Osei. But we have lived in this country and all this has happened. Today, when it is His Excellency John Dramani Mahama, we are seeing people going to court. These few days ahead of us going to be very interesting. Very interesting. I know 2nd April, there will be a hearing on that matter. Whether or not the president has heard. Now, Article 146 is very clear without ambiguities. This is where the removal of the CJ actually kicks in. Looking at the entire 146 spectrum, as I read, there is no such duty on the president to hear the Chief Justice before the mandatory consultation with the Council of State. Indeed, the CJ will have ample time to defend herself. She is even required to go with her lawyers. Any lawyer of her choice. The trial, that is before at the trial, when the committee is formed, the process allows her to defend herself at the committee hearing with any lawyer of her choice or other experts she may so wish. Inherent in the Article 146 removal process is the observation of the principle of natural justice. Now, those who have gone to court, they are also citing Article 23 and Article 296. Some referencing Article 57, Clause 3. All these are laws. Interesting times ahead. I will open my eyes and ears wide, and I will always have my pen and my notebook with me, and I'll be making notes and be learning. After everything, common sense must be applied. For me, I say the law is the application of common sense. You read, you apply common sense. In certain cases, you need interpretation. That is where it goes to the Supreme Court, and then they interpret. So the law is an interesting field. Everybody, the least you can do is to do more reading and research and listen to the experts.
Well,